Hello, and welcome to Your Estate Matters with your hosts, my colleague Greg Bernand and myself, Nicole Garten of Heritage Trust.
Your Estate Matters is a podcast dedicated to everything estates, including building and preserving your legacy.
If it's estate related, we'll be talking about it. We're having the conversations today that will help Canadians protect their families, their assets, and their legacies tomorrow.
Katrina, thanks for being with us here today to discuss estate administration basics. Could you tell us about yourself and your journey to your current role as a lawyer with Lindsay Kenney LLP?
Hi, Greg and Nicole. Thanks for having me. I'm currently an estate planning and administration lawyer at Lindsay Kenney, but I started out over 10 years ago in a more broad legal field. So I did a little bit of litigation, a lot of insurance defense work. So I was in court often enough, much to my chagrin in part. I did a lot of commercial, real estate, M&A type work, and wills and estates. And I really liked the wills and estates work that I did. And I latched onto those practitioners and my colleagues in that area. And since then narrowed my practice more and more into just wills and estates. And here I am. I've now been at Lindsay Kenney for just a few months now, but fully focusing in this area and really enjoying it.
Terrific.
So tell us about your current practice and approach to estate administration.
I was just talking to Greg about this a bit earlier this morning, and I was saying that, clients come to me in a difficult situation in their life. Someone has passed away or is about to pass away. And so I try to make it as simple as possible and as practical as possible, given the circumstances. Every estate is unique and different, and we can only make it as simple as possible in certain scenarios. But I really try to make it easy and straightforward. I handhold clients along the way in a difficult situation.
So you're talking about, I think being a solicitor and drafting wills and estates, but what is exactly is the estate administration? Yeah,
that's a good question. And sometimes I do need to sit back and remind myself of exactly what that is. Estate administration is if someone passes away, when someone passes away, it's really the organization, management, and eventual payout of someone's assets, property, and funds.
So are you generally assisting clients with that, or do you act as executor as well?
I don't act as executor. I work with clients that either have been appointed as executor under someone's will, so appointed as the person to manage everything, or I work with clients when there isn't a will and that client has decided to step in and manage everything.
In the case of an intestacy.
That's right. So intestacy, when someone has passed away without a will.
Right.
So what is probate then?
Probate it's just a document issued by the court, and in BC it's the Supreme Court of British Columbia. Estate law is governed provincially, so every province is a little bit different. But in BC, grant of probate, just a document issued by the court that gives the executor or the personal representative legal authority to manage everything on behalf of a deceased person. So really, it's just a document, and it confirms that a will is in fact the final valid will, and the legal representative is the person that can access and deal with everything.
So when do you need probate?
It's not needed in every case. When someone passes away, it's really only needed if someone asks for it. And that someone could be the land title office. They generally need it in every case. Banks, institutions, insurers, anyone like that, any institution may request grant of probate because they're risk averse. So they want proof of who you are, who the executor is, and that you in fact are the right person to access and be provided with these funds on behalf of a deceased person.
So isn't there a financial threshold where banks will require probate over a certain level?
I would say generally yes, but each bank is a little bit different. So it depends who you speak to at the bank. I would say we sometimes see the threshold being $25,000 and under, and a bank won't mandatorily require grant of probate, but again, it somewhat depends. In the first instance, an individual will be asked for probate, regardless of the dollar value, in my experience. And then sometimes I do work with clients to say, let's write to the bank, let's tell them the circumstances, simple estate, maybe there isn't lots in terms of the funds. Let's see what the bank is willing to accept, rather than this court-issued grant of probate.
Right. And another reason for that is people walking around may not realize some people have multiple wills.
That's right.
And are quite frequent will writers and constructors, so you may not have the valid newest will.
That's right. Sometimes it's hard to keep track, and there is a wills registry in British Columbia. It's with the Vital Statistics Agency, and someone can file notice of their will. It's not a copy, it's just a notice, but that's not mandatory, which is sometimes a little bit confusing because you don't necessarily need to file that will or keep a record of it. If you do, it is good practice because it would show, okay, Greg had a will in 2025, and then as he keeps updating, we see the more recent will, and then the final will might be recorded there.
Absolutely. So what happens if there's no will?
So as we were saying earlier, that's an intestacy, meaning that there isn't a will. There is law that steps in to say who can administer, who has prior right to administer to become that personal representative, and at the end of the day, who inherits. So there is default law in place just in case. That order of priority, generally speaking, is typically a spouse, if there isn't a spouse, adult children, and down the line to family members and all the way through to, trusted friends. It's just somewhat difficult at times because you don't have that document, that will, to give to the bank or any institution to say, I'm the right person. Someone needs to step in.
Right. And actually within that list of persons eligible, you would have public bodies, like the public guardian, which would step in and often will step over more distant relatives saying, well, we don't believe you're probably a beneficiary or an heir.
That's right. So do you want the government to step in to manage your estate if you don't have a will? Something to think about. And you have to pay, or your estate does have to pay that public guardian and trustee if they do administer.
Right. And so there's a list of who's eligible to administer when there's no will. How is the distribution done when there's no will?
Right. So if you don't have a will and you haven't pre-decided your beneficiaries, who inherits, again, you look at the legislation to say who gets what. And it's a similar scheme in terms of who receives the bulk of your estate. So again, spouse would have priority in terms of a portion of the estate. Children would also have a right to a portion. And, the percentages differ depending on whether those children are, in fact, the biological or adopted children of you and that spouse, or maybe that's a step parent. The percentages would differ. And if you don't have close next of kin, those spouses or children, it would go to parents and then siblings and again down the line.
Right. The cutoff is cousins.
That's right. I always have to look at the chart, though, because, every situation is unique. And sometimes people have those distant cousins or family members that don't live within Canada, and it gets a little complicated.
So who manages the estate?
Two situations, and we've somewhat touched on this. If there's a will, you as the will maker get to appoint your executor. And it's always best practice. My clients always appoint primary executor or executors and alternates, maybe one or two alternates as backup. Again, we like to consider all these hypothetical situations, these just in case scenarios. So it's the executor in the first instance with a will. If there isn't a will, someone, again, needs to step in to be the administrator or personal representative.
And what are their main responsibilities?
I could go on for hours, Nicole. An administrator really needs to look at all the assets, property, debts, taxes of an individual and consolidate everything and settle those debts. Keep beneficiaries and other parties that are interested in the estate notified, and eventually pay out. So that's super high level. I could go into great depth on each of these points. But I would say it's really about organizing, managing, notifying, and eventually settling and paying out.
There's a question I was going to ask you because it confuses people. So when there's a will and the executor or alternate executor doesn't administer, then who may apply?
Right. Again, the law does provide for this situation and says that anyone that's interested in the estate can prompt the executor, provide them with a formal notice to say, you have to administer in accordance with the will. If that executor doesn't step up, then anyone can then apply to the court for probate. So there is a recourse under the law in case an executor doesn't, in fact, step into their role.
Right.
So what are some of the common challenges executors face?
There are a lot. And I would say the first thing that comes to mind is it's a significant role. It's a significant job, and it's all about time. An executor does need to take a lot of time and put in a lot of effort in their job. And I would say many of my clients, when they're thinking about who to name as executor, they don't quite realize until I bring it up just the significance of the role and the number of things that an executor needs to do. So time and effort is a huge thing. And I guess that's why they rely on a lawyer to assist them. It's helpful. But one of the other things that comes up often enough is all about organization. So an executor is legally required to put together an accounting, a listing of like ins and outs of estate funds for beneficiaries or successors. And sometimes my clients come to me and they've already expended a ton of funds, out-of-pocket expenses and whatnot, and they haven't kept good receipts or accounting of that. Going back and trying to put that together is difficult. So, the organization and putting together an accounting is sometimes tricky for my clients.
Oh, absolutely. So you've talked about some of the key steps in administering the estate. I think one that we left out was the tax portion. And do you find that really is a stopping ground for or executors that they get very confused by it? The person may not have kept up with their taxes in the past.
That's right.
Or they might have complicated assets.
Definitely an executor's best friend, I would say after the lawyer, is the accountant. And I always remind clients, I would say my favorite line is, I'm not your tax advisor, and I recommend that you speak to an accountant. Definitely an executor needs to bring a deceased tax returns up to date.
Mm-hmm.
They need to, at the end of the day, make sure that final, it's called the date of death return, is filed. It's a regular T1 for that year of death. So let's say someone passed away March 6th, 2025. That tax return needs to be from January 1st to the date of death, the March 6th date. And then an estate, it remains its own legal entity going forward. So it needs to file a regular, an estate return, a T3, for as long as the estate continues. And so a reminder to executors, to my clients is, let's try to wrap up the estate as efficiently, as quickly as possible so that tax returns can be completed and it doesn't need to go on for years and years.
Right. And I think some executors may find themselves in the situation where their deceased friend or family member may have been an owner of a company or the sole director, and they may need to be appointed.
That's right. So they need to step in and deal with that company. If it's an active business, well, hopefully the will maker, the person that's passed away, has considered who will continue to run that company in the interim, whether it is the executor, if there may be a business partner, or if they put together a scheme for backup management. It is a lot to think about. And business owners are a significant portion of my client base. And I would say there are methods to ensure that the business continues, but also ways of dealing with those shares in a tax efficient manner, and also in ways to save on probate fees.
So how long does the process usually take from start to finish?
It depends. My favorite answer after the saying that I'm not a tax practitioner. If it's a fairly simple estate, not too many pieces of real estate, maybe no businesses or whatnot, it can take anywhere from about a year or so. That would be pretty efficient, pretty quick. But it depends, because if grant of probate, if that court approval is needed, that takes time. Right now, the court is taking about 4 months to review applications, which is somewhat lengthy. And that's only at the point of the executor filing their application, asking the court for probate. Before they can file, they actually need to gather all the deceased's assets, secured liabilities, and put that together in a list, and then submit that to the court. So that asset gathering can take quite a while. And then, as we were chatting about earlier, the final item to jump ahead after the probate is issued by the court is settling debts. The taxes can take a while, and then paying out to beneficiaries. And there are timelines that the law imposes that you just can't get around. One of them, for instance, is even once the grant of probate is issued to an executor or an administrator, they must wait 210 days before paying out to beneficiaries, paying out funds, unless they have everyone sign off, everyone being all the individuals involved in the estate. But that 210 days is long. And so even if something is simple and the court is quick by chance, 210 days without everyone's approval must be followed.
So Greg and I, when we're administering estates at Heritage Trust, often it can take a long time for the banks to get us information. You've got to file notification to all the beneficiaries and any intestate heirs. You got to wait, I think, 21 days before, after the sending the notice. So there are a lot of statutory timelines. And then tell us about the clearance certificate process, because that's quite a delay often from the CRA.
That's right. So a clearance certificate is, long and short of that, is the CRA saying someone is all clear and all paid in terms of their taxes. It is required to request a clearance certificate. So a personal representative or executor, once they've submitted the deceased and the estate's final returns, needs to request a clearance certificate, typically through an accountant, and that can take several months to obtain. Of course, clients can make an interim distribution of estate funds to beneficiaries before they understand, or they have that clearance certificate in hand to know, okay, deceased taxes and debts are all settled. And then I always say maintain a holdback, a conservative chunk of change just to settle any unknown taxes or debts. So things don't necessarily need to be fully held up before obtaining the clearance certificate, but there are a number of institutions that an executor needs to wait on.
So what happens if the executor distributes estate funds and then a creditor pops up, or the CRA decides it wants more taxes?
An executor could be found personally liable, meaning that they would have to pay for that debt, that CRA tax out of pocket. At times, they may be able to claim that amount back from beneficiaries, but once funds are paid out to beneficiaries, it's hard to get it paid back, Beneficiaries spend money that they receive at times, and once that car is purchased or that down payment is paid, The executor might not be able to get it back. So it's definitely best to 110% ensure that everything is known and settled.
And I think following the tax clearance is really a risk management tool for the estate. But another one would be, could you speak about advertising for creditors as an executor's duty?
Yeah, there's the option of posting a notice to creditors, which in BC, it's published in a government publication. It's called the Gazette, and it puts forward a notice saying, I am executor or administrator of an estate, and I put a call out to any creditors of this deceased person. They must respond within a set period of time. I believe it's 30 days. And if a creditor does not come forward during that time, then the executor is protected from that claim. So a creditor could not come after the executor if they have a valid claim. Now, a creditor could come forward, make a claim against any beneficiaries of the estate once funds are paid out to them, but at least the executor is protected following that publication.
Right, because in general, if they're a secured creditor, that's generally easy to find out.
It should
they
be
own
known.
the car note, or they're on the mortgage, etc. But it's the general creditors typically that would be a risk.
That's right.
It's always good to do. And also, so what can individuals do now to make estate administration easier for their loved ones?
I would say two things. One is the most obvious: put a will in place, put your incapacity planning documents into place, like a power of attorney or representation agreement. Key to the will is the naming of the executor. The second thing, and I would say I even need to do this, is putting together that just-in-case binder. So something physical, or, it can be digital, but all consolidated together. And that should include your key contacts, contact information for people like lawyers, financial advisors, bank contacts, all of that. It should also include those estate planning documents all together. And one of the biggest things these days are digital assets. So, will your executor, your family members know what accounts you have, usernames, passwords, all of that? Things get locked, like our iPads, our phones. And if someone doesn't have the password to that, well, it can be difficult to access. So something consolidated all together that your executor knows about is a really good idea these days.
So we should mention we have a Canadian Estate Organizer Guide available at estateclub.ca if people want to check that out.
Right. And just speaking of time length of administration, if you have something like that for an executor, everything is already there, the information, who to contact,
That's
to
right.
access it quickly.
What banks a deceased person used to deal with, what insurers, so that it's limited versus needing to write to every single big bank in Canada or credit union. That takes many, many, many months. Most banks have head offices on the East Coast, and their estate departments are slow. As soon as someone passes away, I would say, in my experience, banks aren't that quick at getting information out because they're losing a client. They've passed away. So yeah, definitely best to put that all together for family members and loved ones.
Especially people you would often see in Eastern BC, not unusual to have Alberta accounts in credit unions or Alberta Treasury Board, and people going to the States might have something down in California or Texas. But, people know they have an account. Where's it at?
Yeah, accounts are hard.
Right?
And
those are very difficult to obtain.
Another thing about our assets and accounts these days, a lot of it is online versus getting paper statements. Back in the day, an executor would check the mail and start to see all the accounts and information that would be received. Not so these days. So best.
Yeah, without a mail redirect. Mail redirect was very informative before, and now you get flyers. And
oh yeah, you don't want that.
You know what the sales are at the shopping market.
No,
but,
no thank you.
Yeah.
So how does someone choose the right executor?
It goes back to needing someone that's organized. They should be good with finances, good at keeping track of all the ins and outs. So that's one of the key responsibilities of an executor and traits that they should have. The other one is trust. You want to name someone that you fully trust because you're giving them a big role and you need to know that they're going to do it properly. You should trust them, and then your family, your beneficiaries should be able to trust them as well. And some people don't necessarily have that one key person with all of those traits that they want to appoint. So there is, of course, the option of naming more than one executor. Those co-executors would have to act together, sign off on everything together. But it may be good to think about that one person that's good with taxes, good with money, and then that other person that knows your family and is that trusted advisor on the back end. Of course, there's always the option of a professional trust company. They're in the business of this, as you guys know. Of course, Heritage Trust does this, and they're efficient and they know what's going on. So that's always an option for a client.
And in reviewing the documents, creating wills, etc., was the executor that was the right executor 15 years ago correct today?
Right. Let alone age.
Yes.
Yeah. Definitely worth it to review documents. I would say every few years, but wills, in my experience, have about a 5-year lifespan.
Mm-hmm.
Review them and update them as needed.
Mm-hmm.
So can executors get paid?
Definitely. There is default law that says an executor may claim a fee, a reasonable amount of up to 5% of the value of an estate, and an ongoing management fee if there's trusts. So ongoing work, I believe the prescribed rate is 0.4%, and that's statutorily set. And a will maker can limit that percentage as well. So we could say my executor may only claim a maximum of 2%, for instance, or no executor's fee. So that's what the law sets. As well, with a professional executor, a fee agreement would have to be reviewed and signed by the will maker in advance, and it would form part of the will. So to ease some client's mind, that percentage won't increase in future because you're agreeing to it now.
And that's an advantage because if your assets increase, the fee structure will stay in place for that portion.
That's right.
So, if we've talked about choosing the right executor, I think one of the things too is also, do they have complexity if the family is not local? Like foreign beneficiaries, when we talk about tax issues, distributing to a foreign beneficiary without the right documents in advance can cause you a lot of problems.
That's right. Tax advice right from the get-go is very important, not only looking at what estate assets, what assets the estate has, but also who may be the final beneficiary, because a non-resident beneficiary may be subject to their own jurisdictional tax. For instance, I believe that in the UK, there's inheritance tax that is significant. So a will maker needs to speak to their lawyer about, does the estate pay for that non-residence tax? Typically not. Or is it taxed in the hand of that beneficiary, meaning that portion of that beneficiary's inheritance is maybe less than the other beneficiaries? So yeah, non-residency status is a significant issue that comes up often.
I can say I have a non-resident beneficiary, and they've been complaining because our currency has depreciated to their currency, so they feel they're getting less.
That's right.
But that's just the nature of two currencies, right? So.
Yeah.
So, Katrina, this has been amazing. Do you have any final tips for our listeners?
I guess we've touched on this, but plan ahead. Make it easier on your family and loved ones. Get that will in place so that you can name the executor. And although it's not fun and it takes time yourself to turn your mind to these things and maybe put that just in case binder into place, it does make it a lot easier on everyone. I always say anything that takes you 5 or 10 minutes to do with your bank or your advisor will take your executor a lot longer, many months. So take a little bit of time now and plan ahead.
Katrina, thank you for being with us today. And where can our listeners find you?
I would say the easiest way to find me is to Google Katrina at Lindsay Kenney LLP, and my page will come up. You'll find my email and phone number there, and feel free to reach out at any point.
Terrific.
Great. Thank you so much for joining us.
Thank you.
This podcast is for informational purposes only and should not be considered individual legal, financial, or tax advice. Make sure to consult the advisor of your choice to advise you on your own circumstances. Thank you for joining us for this episode of Your Estate Matters. If you like this podcast, make sure to follow it on your podcast platform of choice.
Whether you are planning your own estate or you're acting as executor for somebody else's, Heritage Trust can help. Partner with Heritage Trust to protect your family, your assets, and your legacy.
If you would like more information about Heritage Trust, please visit our website at heritagetrustcompany.ca.
This podcast is produced by Podfather Creative.